Hi, everyone, and welcome to our last module. I can't believe that we're at the last module already. This course has gone by so fast, and you guys have all been doing an amazing job. This week, we're going to be talking about conflict resolution strategies. Last week, we talked about some things that you could do to prevent conflict, like facilitated IEPs, things like that, bringing in advocates. This week we're going to be talking about how to resolve conflict once, if you can't use any of those prevention strategies. So the four topics we'll be discussing are conflict and sources of conflict. We'll do a review of procedural safeguards, and then we'll talk about mediation and due process. So first off, what is conflict? Conflict is the interaction of interdependent people who perceive incompatible goals and interference from each other in achieving these goals. So the thing I like to think about as conflict is it doesn't have to be anything major. I mean, a lot of times I've gone into my own kids' IEPs. We have a great relationship with each other, but sometimes just something will not go right. Perhaps it's maybe my mood that day. Maybe it's the approach that the team is taking. Maybe it just doesn't feel as collaborative. Maybe it's little things like, they're sitting at the table before I get in there, things like that. So all of those things go into play, and, something can just not go right, and then conflict can occur. So what are the common sources of conflict? There's a lot of research in this area. A lot of times it's design of services. So sometimes the family will not agree on where the placement of for their child, the eligibility. Sometimes there's a lot of conflict that can occur on the throughout the assessment and evaluation process, and determining what students' needs are. So I know for like my kids, deafblindness is a very low incidence disability, and you see this really frequently for families who have children who have low incidence disability, in particular, where they may have this more knowledge of the disability than the educator, just because it is such a low incidence. And so there might be some disagreement as far as what the student needs. And sometimes, I know for my own kids, they have a progressive vision loss. And so sometimes I find that things are changing. Their situation is changing on a frequent basis. And so sometimes what was working, a month ago may not be working now. So it requires the team to really just, keep being flexible and requiring them to reassess the needs on a regular basis. And that requires a lot of times meeting more than once a year. I see that my dog is back there helping me today. Another source of conflict is delivery of services. That's, the determination of those IEP goals, and how is it going to be implemented, and what services are going to be provided so that the student can actually achieve those goals. Then there's relationship issues. Again, sometimes it's just like a personality conflict, or there's a communication breakdown. Sometimes something in the past or current is occurring, so that trust is lost. It's that power struggle, and sometimes it's the view of the student. Sometimes they see it very differently. What you see at home, sometimes you see a very different situation at school, and that can cause conflict. Constraints, so resource restrictions, financial restrictions. We learned earlier in the course that that's not a reason to not provide services to a student, but that doesn't mean that it doesn't occur. And then again, the last thing is knowledge, lack of training or knowledge about the specific disability, or how to serve those particular students. So it's important to always remember to be proactive instead of reactive, because it's really stressful to be in a situation where there's this intense conflict. So no one wants to be in the meeting. It's really stressful. It's a really unpleasant situation. So we know that conflict in special education is a national problem. The Department of Education has said that there's a huge cost associated with this litigation, due process, and that these costs and the dissatisfaction with the system merit serious reform. So that's something that's being thought of and considered throughout the nation, but no change has happened yet. So, what is the problem? Due process hearings, in particular, take a substantial amount of time and money. We know that that these are staggering statistics. National conflict resolution, $90 million a year. Due process hearings can cost $120,000 per hearing on average. And the time spent worrying and planning for that litigation, so many hours. Um, and the sad thing is that the disputes like this divert that attention and the time and the money and the energy that could be otherwise used to educate these children. Um, so if we can take some of this time and energy and put it towards conflict prevention and some of the, building collaboration within the IEP teams, I think that is actually more uh, preferable. So procedural safeguards, we talked about this earlier on in the semester. It gives parents the right to help children and families through the IEP process. It protects children against discrimination. It ensures that free and appropriate public education for students, all students. It outlines the steps for families to resolve conflict. And it talks about that document, the procedural safeguards document that is given to parents at least once a year and upon evaluation. So procedural safeguards, a little bit more about that. Again, there's a prior written notice that we talked about earlier in the semester, and that's a written notice of meetings or any change of placement or change in the IEP needs to be written down and sent to the parents in something called a prior written notice. That is included in the procedural safeguards. Participation in meetings relating to identification, evaluation, and placement. So parents and families need to be invited and actively participate in those meetings. The right to give or deny consent for anything in the IEP and in evaluations. The right to disagree with any decision made by the school. So not everyone has to agree. To avoid discrimination in assessments. Parents also have the ability to seek out independent educational assessments should they desire. I know we've done that in particular when we were getting my son evaluated for dysgraphia and dyslexia. The school district just didn't have the resources in order to provide the comprehensive type of assessment that we felt that we needed for our child. So we went ahead and pursued getting that outside assessment to help the educators see a bigger picture of what was going on for my son. Access to educational records. So if I wanted to see records for my kids, I would be able to do that. And then it gives parents the ability to file due process in order to resolve disputes. So IEP meetings are often the initial point of conflict because everyone is there together, and sometimes you lose sight of why you're there, which is for the student. Everyone has that same goal, but sometimes that whole thing gets lost. So, and it just gets really stressful. So this is an interesting slide about the different types of dispute resolution processes and the different stages. So up until now, we've really been focused on stage 1 and 2, and even prior to that. So we've been talking a lot about family engagement, which is in stage 1, training about how for collaboration, about different disabilities and how to, about the legal aspects of the IEP. And so we've talked a lot about that. If that doesn't work and you end up with some conflict and some disagreement, you can move to stage 2, which, perhaps you might want to get some assistance from an advocate. A parent information center can provide someone to assist you. Or you can get telephone support or ask, bring in an outsider to help. Again, if that doesn't help, it goes to the next level, which is like a facilitated IEP, things like that. So the last module we were talking a little bit about stage 2 and stage 3, and this module we'll be talking about stage 3 and beyond. So that's, mediation, bringing in someone, doing a state complaint, bringing in that third party to help mediate the situation. And then if that doesn't work, it proceeds ahead to a resolution meeting and or a due process meeting. And then, it goes, if it can't be resolved at any point, then it proceeds ahead to a hearing, litigation, and that can take a really, really long time. So what is mediation? It's a way for both parties to negotiate. It's free, voluntary, and confidential. It's a way to help resolve that disagreement with that neutral party. What happens is that the mediator hears both sides of the disagreement and then meets with each party individually to help try to come to some sort of mutual agreement. And what that does is it facilitates that communication between all the parties. So similar to like a facilitator in the IEP would be doing, but this takes it to one step further. So they attempt to come up with a joint agreement by the parties, not the mediator. And if that happens, the document is signed and it's legally binding. And if they don't agree, then the next step is due process. So the good thing is that 70% of mediations do result in signed agreements. So like I said, if mediations don't work, the next process, you can file a state complaint. So that's calling up your state and saying that you're having a problem. I've had a lot of good success with that as well. And a lot of these processes can happen simultaneously. So it's not like you have to proceed from one to another. So it just depends on the situation. So due process is the formal way to resolve disputes based on those procedural safeguards. And it starts with a complaint and ends with that legal decision. So that hearing happens at the very end. It first starts with that written complaint that's filed, and it moves on to a resolution session after that complaint is filed. And if you can't come up with a resolution and an agreement in that formal resolution session, then it continues on throughout the hearing. So due process is something that's provided for in IDEA. It can be made if the issue has to do with identification, evaluation, educational placement of a child with a disability, or the provision of FAPE. So due process hearings can be really, really stressful. Again, they can take a really long time and resources. It's like a courtroom trial. It's very formal. Different people come in to be witnesses to present both sides. Typically, an attorney represents both the educational agency and the parent can be represented by an attorney, or they can represent themselves. And then there's a hearing officer that acts as a judge, and the decision then is ultimately made by that hearing officer. And then 90 days from the due process decision to file a lawsuit in this state or federal court. So if you don't agree with the decision of the hearing officer, you can appeal and proceed ahead. So anyway, that's the end of our lecture today. If you have any questions, please let me know. We are nearing the end, and we'll be focusing on preparing for the final and also just responding to everyone's comments on the final projects. So if you have any questions about the final projects and discussions or anything else, please feel free to reach out to me. And after this course, please let me know if I can help in any sort of way. I'm happy to be a resource. Thanks so much and have a good break.